There is no other way to put it. Roe versus Wade and its progeny are dead. Women in the United States no longer have a constitutional guaranteed right to an abortion. This video explains the how and the why of everything that happened. And to do that, we have to start with the history of how we got Roe versus Wade in the first place. What is the source of a constitutional right to an abortion in the United States? It is one of the rights which fall under a general right to privacy, which is the right of people to make personal decisions regarding intimate matters. Now, when you're talking about the right to privacy, you're talking about unenumerated rights in the Constitution. When the founders were drafting the Constitution, they did not set out to list all of the rights which Americans could conceivably claim. They were well aware that by naming some of the rights but not others, future governments might deny the people rights that the founders believed were important. And this is why the Federalists originally did not want a Bill of Rights to be included in the Constitution itself. And as a compromise, rather than make a long list of rights, the founders included the Ninth Amendment, which states, quote, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." James Madison, in particular, reportedly said that the government should never use the Bill of Rights as an excuse to increase its powers over areas of life that were not enumerated in the Constitution. Now, the Supreme Court really began fleshing out unenumerated rights in the mid-20th century, particularly in a case called Griswold versus Connecticut, which voided a statute that made it illegal for married people to buy contraception. The court wrote that privacy was one of the values implied by the First Amendment, which protects the right of association between people by the Fourth Amendment, which allows people to be secure in their persons from government intrusions, and through the 14th Amendment's guarantee of due process. Now, in that case, after reviewing a line of cases in which the Supreme Court identified rights not explicitly enumerated in the Constitution, Justice Douglas argued that the court could infer a right to privacy by looking at zones of privacy protected by other parts of the Constitution in overlapping protections. Quote, "Various guarantees create zones of privacy. The right of association contained in the penumbra of the First Amendment is one, as we have seen. The Third Amendment in its prohibition against quartering of soldiers in any house in time of peace without the consent of the owner is another facet of that privacy. The Fourth Amendment explicitly affirms the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. The Fifth Amendment in its self-incrimination clause enables the citizen to create a zone of privacy which government may not force him to surrender to his detriment. The Ninth Amendment provides the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." Now, Griswold upheld the right of married couples to decide private issues of contraception, and 7 years later, Eisenstadt versus Baird extended Griswold's holding to unmarried people, using some of the same logic. And following Griswold, the court upheld a right to privacy and struck down a number of laws, including those prohibiting interracial marriage. The Constitution does not explicitly say anything about marriage, and in the mid-19th century, the law offered interracial couples no protection, even from prosecution. In Loving versus Virginia, the court held that a Virginia law criminalizing interracial marriage violated the Due Process Clause of the 14th Amendment. Chief Justice Earl Warren wrote, "Under our Constitution, the freedom to marry or not marry a person of another race resides with the individual and cannot be infringed by the state." And continuing with that logic, the court also relied on the 14th Amendment's due process laws to strike down laws banning prisoners from getting married while in prison. And in continuing in those line of cases, in 1973, Roe versus Wade established a constitutional right to an abortion through the Fifth Amendment, among others. Now, the Fifth Amendment says no person shall be deprived of life, liberty, or property without due process of law. Now, courts have interpreted two types of due process. One is procedural due process, which are the rules that the government must follow, such as giving a person notice, a hearing, and a fair tribunal. And then there's what's called substantive due process, which is the idea that allows courts to establish and protect certain fundamental rights from government interference, even if procedural protections are present or the rights are unenumerated. Now, the Roe opinion begins with a long review of the medical history of abortion. It reviews the history of abortion laws, finding that many prohibitions on abortion were relatively modern. The court reviewed many religious and philosophical traditions, which contained many different views about when or if the unborn could be considered people during different stages of pregnancy. And the court ruled that the word person, as used in the Constitution, did not include the unborn. The court concluded that the 14th Amendment's concept of personal liberty includes a right of personal privacy over certain areas, which include whether a woman terminates a pregnancy or not. And the court also recognized that the government could not make a choice about whether the person continues a pregnancy. And the court held that the state had valid interests that justified regulation of pregnancy, and that the state's interest increased as the pregnancy progressed. Then, almost 20 years later, the Supreme Court decided another abortion case that substantially revised Roe. That's Planned Parenthood versus Casey. That case tested whether states had the right right to restrict abortion, including during the first trimester. The Pennsylvania regulations included a mandatory waiting period, spousal notification, and parental consent. In the Casey decision, the Supreme Court overturned Roe's trimester rule in favor of a viability analysis and lowered the standard of review for abortion restrictions from strict scrutiny to an undue burden test. And under Casey's undue burden test, abortion restrictions were unconstitutional if they had the purpose or effect of placing a substantial obstacle in the path of a woman seeking an abortion of a non-viable fetus. The court held that states could require parental consent for a minor's abortion, require waiting period between seeking and obtaining an abortion, and require detailed, informed consent, including medical information about the abortion. But the state couldn't require a woman to sign a form stating that she had given notice to her husband that she was having an abortion. And again, following in these cases, in 2003, the Supreme Court cited Loving, Griswold, Eisenstadt, Casey, and Roe in striking down a Texas law that criminalized sexual intimacy by same-sex couples, but not identical conduct by straight couples. The court held that the law violated the 14th Amendment's due process clause, as adults are free to engage in private conduct in the exercise of their liberty under the due process clause. Quote, their right to liberty under the due process clause gives them the full right to engage in their conduct without intervention of the government. And notably, Justice Scalia dissented in this case, stating that the logic of the decision would, of course, permit same-sex marriage. And in 2012, following in that case, the court proved him right by legalizing same-sex marriage, citing the same string of cases that establish the right to choose one's intimate relationships and whether to have children. And when the court decided that case, Obergefell versus Hodges, it observed that if a person has the right to choose whether to have an abortion, then they have the right to marry the person of their choice. Now, in the aftermath of Planned Parenthood versus Casey, states enacted more and more restrictions on the right to an abortion. Over the years, federal courts have analyzed nearly every kind of abortion restriction imaginable, invalidating some of them and upholding others. But one thing never changed: the court's original ruling that the right to privacy included the right to a legal abortion. But the recent case of Dobbs versus Jackson Women's Health Organization changed all of that. The Jackson Women's Health Organization brought this lawsuit to challenge the constitutionality of Mississippi's Gestational Age Act, which states, except in a medical emergency or in the case of a severe fetal abnormality, a person shall not intentionally or knowingly perform or induce an abortion of an unborn human being if the probable gestational age of the unborn human being has been determined to be greater than 15 weeks. Jackson Women's Health was the only remaining abortion clinic in the state. The organization won at the federal district court level, and the district court decision was upheld by the Fifth Circuit Court of Appeals. Mississippi appealed to the Supreme Court. Now, some legal commentators expected the Supreme Court to simply overturn Casey's viability analysis and replace it with a right to an abortion that stops at 15 weeks. And in fact, this is what Justice Roberts advocated in his concurring opinion. However, a majority of the Supreme Court decided to overrule Roe and Casey from the roots and allow each state to decide whether there is a right to an abortion or not. The majority opinion was written by Justice Alito, and the vote to overturn Roe was 5-4. Justices Thomas, Gorsuch, Kavanaugh, and Barrett joined Alito's opinion. Chief Justice John Roberts did not join in the opinion in overturning Roe, but filed a separate concurring opinion, which he agreed with the result, which is why you'll see some people call this a 6-3 decision. Justices Kagan, Sotomayor, and Breyer dissented. Now, Justice Alito's opinion begins by stating that abortion presents a profound moral issue on which Americans hold sharply conflicting views. The Constitution's text does not refer to abortion. Alito concedes that not all rights recognized by the court have to be mentioned in the Constitution's text. As I explained earlier, the court has held that due process guarantees of the 5th and 14th Amendments protect certain substantive rights that are not listed in the Constitution. The general idea is that certain liberties are so important that the state cannot infringe on them without a compelling reason, no matter how much procedural due process is given. And Justice Alito states that the Due Process Clause protects the right to interracial marriage, the right to use contraception, and the right to same-sex marriage, but it does not guarantee the right to abortion. Why? Well, according to the majority, the test for unenumerated rights is whether the right is deeply rooted in the nation's history and tradition and implicit in the concept of ordered liberty. And according to Justice Alito, abortion doesn't qualify under that standard. And in setting forth this test for which unenumerated rights are permissible, Alito cites Washington versus Glucksberg, the case which found that there was no constitutional right to a physician-assisted suicide. Abortion is like assisted suicide because, according to the majority, neither can trace their roots to the founding of America. The Alito opinion goes on at great length about the history of abortion in America. He states that until the latter part of the 20th century, such a right was entirely unknown in American law. And indeed, when the 14th Amendment was adopted, 3/4 of the states made abortion a crime at all stages of pregnancy. And the majority opinion says that the 50 years between Roe and the present day do not carry any weight in establishing that that right is deeply rooted, or that women relied on it in organizing their lives. The majority opinion concludes that Roe's holding that abortion was a liberty interest protected by due process was incorrect. The Roe decision said, quote, "The right of privacy, whether it be founded in the 14th Amendment's concept of personal liberty and restrictions upon state action, as we feel it is, or as the district court determined in the 9th Amendment's preservation of rights to the people, is broad enough to encompass a woman's decision whether or not to terminate her pregnancy." Now, Alito criticized the justices who wrote this, saying that they couldn't really put their finger on the nature of the right and it was decided on feelings. And there's always been controversy about that. In fact, many commentators have argued that the court made a mistake in grounding the right to an abortion in the substantive due process clause. Justice Ginsburg argued that the court should have decided Roe based on the Equal Protection Clause or the Privileges and Immunities Clause, which would have provided more durable protection of the right. And in Dobbs, several constitutional law professors filed amicus briefs arguing that the right to an abortion is rooted in the Equal Protection Clause. But Justice Alito said that the Equal Protection Clause is inapplicable because the court had already ruled that abortion is not a sex-based classification. Justice Alito rejected calls to preserve Roe and Casey because of stare decisis. He said that the concept is not a straitjacket when a ruling is grievously incorrect, and listed other landmark decisions which upended precedent, like Brown versus Board of Education, which overruled Plessy versus Ferguson's separate but equal doctrine. And then there is stare decisis, the idea that the court should follow precedent to foster predictability unless it has a very good reason not to. And in assessing whether stare decisis applied, the court looked to several factors: the nature of the court's error, the quality of the reasoning, the workability of the standard, its effect on other parts of the law, and reliance interests. Justice Alito said stare decisis was not applicable because the original Roe decision, as modified by Casey, is, quote, egregiously wrong. In support of its decision, the majority opinion cites 30 other cases where the court has overturned prior precedent. As to the 5 factors, Justice Alito said that Roe was fundamentally unfair because it foreclosed the opportunity for anti-abortion advocates to lobby their government for change. Quote, "Those on the losing side, those who sought to advance the state's interest in fetal life, could no longer seek to persuade their elected representatives to adopt policies consistent with their views." Though the statement ignores the decades of lawmaking around abortion, where legislatures passed abortion restrictions in response to the democratic process. And as to the workability factor, Alito said that as a practical matter, the undue burden test was too confusing to apply. Though he also criticized Roe's original trimester framework as being plucked out of nowhere. And in a stunningly short section, Alito wrote that overturning the precedent would not hurt women because there's no evidence that women rely on the right to abortion in living their lives. He said, quote, "Conventional concrete reliance interests are not present here." And he concluded that the right to an abortion had nothing in common with other types of interests that people rely on, like contract and property rights, because abortion is unplanned. And he said that if women really think they rely on the right to abortion, they should vote. He dismissed generalized issues of reliance by saying, quote, "The court is ill-equipped to assess generalized assertions about the national psyche." Now, obviously, 4 other justices, Roberts, Sotomayor, Kagan, and Breyer, criticized the majority for overruling 2 long-standing precedents. Justice Roberts' concurring opinion, which we'll talk about more in a second, supported upholding Roe because of stare decisis. And meanwhile, the dissenters disagreed with the majority's conclusion that it can reverse these abortion cases without undermining other fundamental rights. They wrote, quote, "Think of someone telling you that the Jenga tower simply will not collapse." However, Justice Alito addressed their concerns by stating that the right to same-sex intimate acts, the right to contraception, and the right to same-sex marriage were quantifiably different than the right to an abortion. Unlike those rights, abortion terminates a human life. It affects, quote, "potential life," whereas those other rights do not. He said, quote, "Nothing in this opinion should be understood to cast doubt on precedents that do not concern abortion." Though it should be noted that this distinction between rights that implicate potential life is not in the Constitution and is not particularly well supported in this context. Justice Alito goes on to say that since abortion doesn't implicate any fundamental right, then Mississippi's law should not be judged according to the heightened scrutiny that the court affords fundamental rights. Instead, the majority opinion says that abortion restrictions should be judged using the rational basis standard of review, which is the most lenient standard of review. Basically, almost no law ever fails rational basis. Now, it's relatively easy for state laws to survive rational basis scrutiny, and the laws are upheld as long as there is a rational basis which the legislature could have thought it would serve the legitimate state interests. And Alito had no problem finding that Mississippi statute met that standard, since it asserted the state's interest in protecting the life of the unborn, and because it regulated the medical procedure that is generally used for abortions after the 15th week. And therefore, the opinion concluded the abortion provider's challenge to the law had to fail. And the Alito opinion did not analyze a woman's interest in obtaining an abortion after 15 weeks of pregnancy because, under the rational basis review the court outlined, it wasn't necessary to a determination of this case. And that takes us to the Roberts Concurrence. Now, the concurrences and the dissents do not carry the force of law. There was a majority for the court, and that is now the law. But examining these other concurrences and dissents is interesting to let us know where the court might be going in the future and what the other alternatives were. With respect to the Roberts Concurrence, Chief Justice Roberts agreed with the decision to uphold the Mississippi law, but he would have done so without formally overturning Roe and Casey. Roberts was prepared to uphold the constitutional right to an abortion, but he would have eliminated the viability analysis that was in place in Casey. He would have characterized Roe and Casey as adopting two distinct rules of constitutional law: a woman's right to end a pregnancy and the state's power to override a woman's right when a fetus becomes viable. Justice Roberts said that the viability line, quote, never made any sense. The right to terminate a pregnancy should, quote, extend far enough to ensure a reasonable opportunity to choose, but need not extend any further. Roberts briefly surveys international law and concludes that the general proposition is to allow abortions until around 12 to 15 weeks, without regard to the viability of the fetus. Roberts also points out that Mississippi did not ask the court to eliminate the right to an abortion. The basic request was straightforward. He wrote that it was to clarify whether abortion prohibitions before viability are always unconstitutional. For Roberts, all of these factors indicated that the best way to balance the interest was to use judicial restraint. He would have eliminated the viability standard, but upheld the right to an abortion. Justice Roberts first suggested this compromise during oral arguments, but he was unable to sway the 5 other justices. Then there are the concurrences from Justices Kavanaugh and Thomas. Justice Brett Kavanaugh said that in his view, the Constitution is neutral on abortion. Since the Constitution is neutral, then, quote, this court must also be scrupulously neutral about abortion. Kavanaugh emphasized that the court wasn't outlawing abortion nationwide and was instead leaving the decision to the states. He wrote that the 9 unelected members of this court do not possess the constitutional authority to override the democratic process and to decree either pro-life or pro-choice abortion policy for all 330 people living in the United States. The rest of Kavanaugh's opinion was designed to reassure people that this wasn't a radical opinion that would upend other cases like Griswold and Obergefell. And he anticipates some of the major legal issues that are probably coming, particularly whether a state can ban its residents from traveling to another state to obtain an abortion, or whether a state can retroactively punish people who had abortions. He says that these are not hard questions. The answer to both of them is no. Though this is just a concurrence, these answers in this concurrence have no legal weight since these questions were before the court and no other justices agreed with his conclusions. So that takes us to Thomas's concurrence, which is sort of the opposite of Kavanaugh's concurrence. Justice Thomas wrote a concurrence to state that while he agreed with the majority opinion that there was never a due process right to abortion, the court should also make it clear that there was no such thing as substantive due process at all. Justice Thomas believes that the Constitution's Due Process Clause only addresses the processes the government uses before taking a person's life, liberty, or property, and it has nothing to say about the substance of the person's rights. He left no doubt about what he thought about rights to gay marriage, contraception, and same-sex intimate conduct. Quote, in future cases, we should reconsider all of the court's substantive due process precedents, including Griswold, Lawrence, and Obergefell. Though critics noted that Thomas did not address the similar case of Loving versus Virginia, the case that legalized interracial marriage and protects the legitimacy of Thomas's own marriage, it's hard to square a deeply rooted analysis with keeping Loving versus Virginia intact if the court is going to go after the rest of the unenumerated rights cases. However, Loving was also grounded in equal protection. It is related to, but not totally dependent on, the substantive due process cases he wants to overturn. That takes us to the dissent of Justices Breyer, Sotomayor, and Kagan. The dissenters critiqued the majority's claim that they were simply returning the issue to state legislatures where it belongs. Quote, we believe in a constitution that puts some issues off limits to majority rule. In other words, the dissenting opinion warns that it is dangerous for the majority to have total control over minority rights. The dissent rejects Alito's claim that Roe and Casey just randomly appeared, that they came from nowhere and went nowhere. This, they write, is not true. The dissenting opinion takes issue with Alito's statement that Casey and Roe didn't allow courts to even consider consider whether the state has an interest in promoting life. And the dissent says that part of the reason that Casey departed from the Roe trimester analysis was because the court recognized that after 2 decades, the Roe framework did not give states sufficient ability to regulate abortion prior to viability. Quote, the strength of those state interests is exactly why the court allowed greater restrictions on the abortion right than on other rights derived from the 14th Amendment. The dissent goes on to say that, quote, what Roe and Casey also recognize, which today's majority does not, is that a woman's freedom and equality are likewise involved. That fact, the presence of countervailing interest, is what made the abortion question hard and what necessitated balancing. The majority scoffs at that idea, castigating us for repeatedly praising the balance the 2 cases arrived at, with the word balance in scare quotes. To the majority, balance is a dirty word, as moderation is a foreign concept. The dissenters also disagreed with Alito's insistence that the right to an abortion must be deeply rooted in the country's history. The court, quote, makes this change based on a single question: did the reproductive right recognized in Roe and Casey exist in 1868, the year when the 14th Amendment was ratified? The majority says, and with this much we agree, that the answer to this question is no. In 1868, there was no nationwide right to end a pregnancy and no thought that the 14th Amendment provided one. But the dissent concludes that it doesn't make sense to ask what was in the minds of the people who ratified the amendment in 1868, and more to the point, quote, people did not ratify the 14th Amendment. Men did. So it is perhaps not surprising that the ratifiers were not perfectly attuned to the importance of reproductive rights for women's liberty or for their capacity to participate as equal members in our nation. The dissent notes that Alito still thought it was necessary to trace hostility to abortion and, of course, the women's rights back to the 1300s. Justice Alito relied heavily on the writings of people like Matthew Hale, a British jurist who presided at early American witch trials and believed women were property of their husbands. And the dissent doesn't see why Hale's writings or any thoughts by people before the Revolutionary War should play a role in what is acceptable today. Quote, first, it is not clear what relevance such early history should have, even to the majority. And then the court cites the Bruin gun rights case, which was decided last week, where the court held that, quote, historical evidence that long predates ratification may not illuminate the scope of the right. And the last bit is a dig at the majority opinion in Bruin, where the same justices who overruled Roe and Casey concluded that when it came to guns, it didn't actually matter if the people were allowed to carry concealed firearms prior to ratification of the Second Amendment. And the dissent accuses the majority of picking and choosing the history that supports the outcome they want. Quote, if early history obviously supported abortion rights, the majority would no doubt say that only the views of the 14th Amendment's ratifiers were germane. And many people have accused Alito of this sort of Goldilocks quasi-historical analysis, that the rights can't be too old and they also can't be too new. Roe has been the law for 50 years, and that does not qualify, according to Alito, as being deeply rooted. And the leaked draft attracted attention from historians who said that Alito got the early history of abortion wrong. Many states Alito listed as banning all abortion actually banned it only after quickening and did not make abortion criminal at all. The same historical evidence made it into the official majority opinion. But the dissenters took note of this controversy, saying, quote, embarrassingly for the majority, early law in fact does provide some support for abortion rights. Common law authorities did not treat abortion as a crime before quickening, the point when the fetus has moved in the womb. And early American law followed the common law rules, so the criminal law of that early time might be taken as roughly consonant with Roe's and Casey's different treatment of early and late abortions. And this is often a controversy when you're talking about originalism. In some sense, both the majority and the dissent are correct. At many times in American history, but not all, states criminalized abortions. And at many times in American history, abortion was permitted, and not just in the 20th century. This just shows how difficult it is to use historical evidence to find the right interpretation of the text. And since early American law allowed for legal abortion before quickening, the dissent says Alito focuses on modern law, where he concludes that because most states criminalized abortion in the decades before Roe was decided, the right wasn't deeply rooted. And again, the dissent points out the majority for the perceived hypocrisy given the Bruin decision. Quote, had the pre-Roe liberalization of abortion laws occurred more quickly and more widely in the 20th century, the majority would say, once again, that only the ratifiers' views are germane. And the dissent ends by accusing Alito of erasing women and their interests from its opinion. Quote, the majority would allow states to ban abortion from conception onwards because it does not think forced childbirth at all implicates women's rights to equality and freedom. Today's court, that is, does not think there is anything of constitutional significance attached to a woman's control of her body and the path of her life. Roe and Casey thought that one-sided view misguided. In some sense, that is a difference in a nutshell between our precedents and the majority opinion. The constitutional regime we have lived in for the last 50 years recognized competing interests and sought to balance between them. The constitutional regime we enter today erases the woman's interest and recognizes only the states or the federal governments. Now, the dissent tears into the majority's stare decisis analysis, noting that, quote, the court may not overrule a decision, even a constitutional one, without a special justification. And as to the other factors, whether the standard is workable, whether there have been changes in the law or fact, and whether women relied on the right to abortion, the dissent takes Alito to task. Quote, the standards Roe and Casey set out are perfectly workable. No changes in either law or fact have eroded the two decisions, and tens of millions of American women have relied and continue to rely on the right to abortion. So, under traditional stare decisis principles, the majority has no special justification for the harm it causes. And according to the dissent, quote, the majority comes close to conceding that point. The majority barely mentions any legal or factual changes that have occurred since Roe and Casey. It suggests the two decisions are hard for courts to implement, but cannot prove its case. In the end, the majority says all it must say to override stare decisis is one thing, that it believes Roe and Casey egregiously wrong. That rule could equally spell the end of any precedent with which a bare majority of the present court disagrees. And the dissent makes a legal realism point incredibly bluntly. Quote, the majority has overruled Roe and Casey for one and only one reason, because it has always despised them, and now it has the votes to discard them. The majority thereby substitutes a rule by judges for the rule of law. Now, I know a lot of people are upset about this decision, and we'll talk more about what can be done in the future. But one thing you can do right now is that there is a company that I work with called Tab for a Cause, which lets you raise money for charity just by opening tabs and browsing the internet. Now, Tab for a Cause responded to your request, and they just launched Tab for Reproductive Health, which lets you raise money for nonprofit organizations protecting and providing access to reproductive health care like the Center for Reproductive Rights and Planned Parenthood. I know this is just a little thing, but it's something that you can do right now. The way it works is that Tab for a Cause is a browser extension that allows you to pick the charity of your choice, and then every time you open up a new tab, instead of displaying a blank page, it displays a customizable tab with a couple of tiny ads. And the money that you generate is then given to the charity of your choice. You can see in real time how much money is being generated, and you can even customize this tab the way that you like it. And LegalEagle tabbers alone have raised over $35,000 for charity. I know this because Tab for a Cause's finances are 100% transparent. So you can see for yourself how much you've raised and where it's gone. So if that sounds interesting to you, if you'd like to make a very small difference, all you have to do is click on the link that's on screen right now or in the description and install the browser extension. And that's it. Then every page that you open will create revenue that goes to charity. So all you have to do is click on the link that's on screen right now or in the description to install the browser extension. That's it. And then every page you open will create revenue that goes to charity. So all you have to do is click on the link that's on screen. And we'll talk about more in the future what else you can do in the wake of the Dobbs decision.